Greetings and good evening. Good evening. I am Dr. Aisha Davis. I'm an international human rights advocate, WOMAI ambassadorial representative appointed to Vienna, Austria, and I'm also the mother of William Adams. I took some notes and I'm going to run through a timeline of some egregious acts that's being done to my son within the Gwinnett County Judicial System and the Gwinnett County Sheriff's Department. My family has reason to believe we are in danger through possible plausible deniability from Judge Tadia Whitner of the Gwinnett County Superior Court, and imminent danger from deputies and or the Sheriff Kebo Taylor of the Gwinnett County Sheriff's Department for our attempts to expose judicial corruption and the constitutional rights violation of my son, William Adams, who is currently being detained in the Gwinnett County Jail in their solitary confinement unit since May 19, 2022. In retaliation of his attempts to represent himself and the filing of several motions to Judge Tadia Whitner to enforce the adherence of his constitutional rights by the Gwinnett County DA's office and ADA Samantha Roth. In addition to filing to represent himself to go pro se, William filed a motion to dismiss counsel, fair notice of rebuttal, a motion to waive counsel, which all have been dismissed or denied, with subliminal advice to not submit anything further on behalf of himself as of May 31st, 2022. On this same date, we believe the Gwinnett County Jail was instructed in a plausibly deniable way by Judge Tadia Whitner that William be restricted of all outside communication, mainly via phone and mail, and he be kept in solitary confinement unit for a minimum of 60 days. William asked to file a grievance for this finding and had camera footage to be provided for the accusation, but he was ignored by the jail deputies and not submitted the grievance through the process, which is what's required in order that inmates are allowed to file lawsuits. A little more background into these constitutional and civil rights violations. In the month of January 2022, William released his attorney, Mr. Robert Lamar Booker of Robert Law, LLC, from service due to his egregiously high level of inadequate representation. On March 14th, William filed a motion to proceed pro se, which means to represent himself. On March 28th, William filed an additional motion to adopt all motions previously filed by his attorney. On March 30th, William's motions to adopt all motions filed by the attorney was dismissed. On April 8th, attorney Robert Booker filed a motion to withdraw as counsel, though he was already terminated by William back in January. Judge Tadia Whitner scheduled a hearing for April 14th to hear William's pro se motion and to address the attorney's status. At that hearing on April 14th at the Gwinnett County Superior Court, 75 Langley Drive, Lawrenceville, Georgia, Judge Tadia Whitner stated that she would be requiring a mental competency evaluation in order to allow William to become a pro se litigant. Backing up just a little bit, upon greeting the judge, William asked if he may speak on the record, in which he read out several things in regards to why he's released his attorney. He further stated he is knowingly, intelligently, freely, and voluntarily making a decision to represent himself, and sent a special prayer that the court adhere to his request. Do please note, the statement of special prayer is a reference to a legal term. Judge Tadia Whitner responded to William's statement, announcing that she would be requiring that he receive a mental competency evaluation in order for her to allow him to proceed pro se, and that she would be also appointing him an attorney. William stated on the record that I do not want an attorney appointed to me. I would like to represent myself. Judge Whitner insisted on appointing an attorney. William further stated, let the record reflect that I do not consent to or accept the appointment of your attorney and would like to waive my right to counsel. Judge Whitner insisted that he be appointed counsel. William then asked, what gives you the right to appoint me an attorney without my consent? Judge Whitner responded in her official capacity, on the record, boastful, unprofessional, and a prideful demeanor, and I quote, this black robe gives me the right, end quote, while popping the collar of her robe when she said it. The court went silent at the exhibit of this bold abuse of power under the color of law, according to Title 42 of the United States Code. Now, according to the Sixth Amendment of the United States Constitution, William is guaranteed the right to represent himself. The Sixth Amendment lists no judicial requirements other than the person being knowingly, freely, and intelligently, voluntarily making a choice to represent oneself, as self-representation, of course, is at one's own risk. William has expressed this term in open court, in addition to skillfully drafting motions in the required legal style, as you can see here, and has clearly articulated his right to waive counsel according to the Sixth Amendment, thus reflecting his competency. But to no avail was William heard, and Judge Chadiha Whitner has forced an appointed attorney upon William, a public defender, Mary Ann F. Blend, which again William adamantly stated he would like the record to reflect that he does not accept counsel, wishes to waive his right to counsel, and proceed to represent himself. Please note the transcripts of this hearing are of course unavailable in the Gwinnett County Clerk's Office as of June 13, 2022. On April 19, 2022, Judge Chadiha Whitner filed an order for an appointment of counsel for an indigent person, stating in this order that William has satisfied the court that he is unable to pay an attorney and does not waive his right to an attorney. Number one, I personally retained counsel for William from the beginning of this case, and I've maintained counsel in place until they begin to inadequately serve William. He has never given any information to satisfy the court that he is indigent or any form of poor. My family has exhausted an extensive amount of funds for the defense of this case and sustainability of William while in the jail system. We have proof that this is falsified documentation on court records signed by Judge Chadiha Whitner, as it pertains to her deeming William an indigent person. William filed an attorney comment form with the Gwinnett County Clerk's Office on March the 2nd. I'm taking you back just a little bit, where he states, and I quote, "Defendant is simply seeking new representation personally, not a public defender, which would impose on the courts." Now, please keep in mind that this is prior to the hearing on April 14th, where he stated that he does not accept counsel and waives his right to counsel. On April 26th, Judge Chadiha Whitner filed in the Clerk of Courts an order for psychiatric evaluation in reference to competency to stand trial. This is the first red flag of the impending denial. She already named it a competency to stand trial, not a competency to represent himself evaluation. It further reads, and I quote, "It is hereby ordered that the Department of Behavioral Health and Developmental Disabilities shall conduct an evaluating examination." It further reads, and I quote, "It is hereby ordered that the Department of Behavioral Health and Developmental Disabilities shall conduct an evaluative examination of the defendant, provide treatment if appropriate, and to provide this court a report of diagnosis, prognosis, and its findings with respect to competency to stand trial. Whether the accused is capable of understanding the nature of the proceeding, whether the accused comprehends his or her own condition in reference to the proceeding against him or her, and whether the accused suffers from any mental disorders, disease, or defect that would impair him or her to the extent that he or she would be unable to assist counsel in the preparation of a defense," end quote. It further states, "It's further ordered that any medical and mental health provider, community service board, or jail or prison mental health services, when requested, provide copies of the defendant's clinical, psychiatric, psychological, and/or medical records to include substance abuse treatment to the DBHDD within 3 days of receipt of a copy of this order in an effort to facilitate the accurate and timely evaluation of the defendant," end quote. This order serves in lieu of other permissions or release of information forms required by any agency. Now, please understand that we now know that this means Judge Chadiha Whitner has taken full control of William's mental and medical rights of choice and has positioned herself as a medical proxy with no just cause. Judge Chadiha Whitner has unlawfully revoked and deceptively violated William's constitutional civil liberty of privacy and medical choice. It is not her right, but an abuse of power to place such order instructing the Department of Behavioral Health Development Disabilities to provide medical treatment if they deem it appropriate and render diagnosis, prognosis, and its finding of an able-bodied, fully capacitated citizen directly to her. By this order or action, Judge Whitner has illegally and erroneously positioned herself as a medical proxy for William on behalf of Gwinnett County and the state of Georgia in the above order. We further believe these statements are plausibly instructive to all involved parties of her predetermined and unfavorable desired outcome against William, thus violating his 14th Amendment right to have no state make or enforce any law which shall abridge the privileges of his immunity of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within his jurisdiction the equal protection of the law. We have reason to believe they are attempting to provoke William to a psychotic break and a mental decline by the cruel and unusual punishment by the deputies of the Gwinnett County Sheriff's Department in solitary confinement, that he may be deemed incompetent to proceed pro se and be denied his Sixth Amendment right to represent himself. A right that does not belong to Judge Whitner, but according to the power of her black robe that she stated, she seems to think so. The order for mental health evaluation was only sent to the Gwinnett County District Attorney's Office, the Georgia Department of Behavioral Health and Developmental Disabilities, and the Gwinnett County Sheriff's Department Mental Health Liaison. It was never sent to William or his court-appointed defense attorney. Please see the CCs on this order. So we have reason to believe that the adherence to these plausible instructions, the Gwinnett County Sheriff's Department is now attempting to create a mental health history for William to appease the orders of Judge Tadia Whitner. Now, in moving forward, on May 2nd, 2022, William filed several additional motions, a motion to dismiss counsel, fair notice of rebuttal, but all were dismissed. On May 19th, William drafted several motions and had them notarized by the jail notary and mailed to the clerk's office. May 23rd, the court received Williams' motions for fair notice request for production, a motion to waive counsel, a copy request to receive the transcript of the hearing that was held on April 14, 2022, and a motion to produce, and a motion to compel full disclosure, and also a certificate of service. On May 31st, all motions from May 23rd were dismissed by Judge Tadia Whitner, stated in the order of dismissal that William appears to be represented by Mary Ann Bland and cannot represent himself simultaneously. Thus, her reason to have enforced counsel to be in place to prevent William from asserting his constitutional rights be adhered to and to be provided with the due process of law without further delay from inadequate attorneys. Please note, to date, William has not heard from the appointed counsel, Mary Ann Bland. Now, as of May 19th, William was conveniently placed in solitary confinement. After he had his documents notarized, the deputies accused him of trumped-up charges that he was involved in a fight. William requested that camera footage be presented. Of course, he was denied. Thus, we have reason to believe it's in retaliation for his multiple motions and challenges against Judge Tadia Whitner and the Gwinnett County Sheriff's Department in defense of his constitutional rights. William was told he would have to serve 6 days in solitary confinement, but upon May 23, 2022, William's time was randomly increased to 50 days minimum in solitary confinement. William rebutted, "But I was offered 6 days." Deputies responded, "There is no record of a 6-day offer in our system." William asked for an appeal, which was held on May 31st. His rebuttal was denied, and an additional 10 days was added for a total of 73 days in solitary confinement for an alleged fight. This equates to cruel and unusual punishment, which is a violation of the 8th Amendment. Please note, pay very close attention to the correlation between the dates of these instances, as well as the dismissal and of the decisions made from Judge Tadia Whitner. We have reason to believe plausible deniability is at play. William has since filed motions against the Gwinnett County Sheriff's Department on June 8, 2022, and Gwinnett County Administrative Office of the Courts back in May 6. He further filed civil actions against Judge Tadia Whitner in the U.S. District Court. On June 12, 2022, our family received a recorded call of William yelling that they don't let him out of his cell for days at a time, and that he was to hurry off the phone before they tase him if they see him on the phone. This call lasted 28 seconds. Another phone call on June 14th and sounded completely distressed and frazzled to give me instructions on how to assist him, and stated he does not get out of the cell for several days at a time. I asked William, are they using excessive force against you? He attempted to ignore me, and I said to him, you have to tell me. And he said, no, I don't. I won't allow it, as if he's being threatened or afraid of the repercussions for telling me. On June 29th, William requested a food package be sent to him. On July 4th, William called and shared that on July 1st, a level 3 mentally ill inmate was placed in his cell. The inmate told the deputy that he was not allowed to share a cell because of his mental status. This deputy advised the inmate that he was no longer on a mental status and was allowed to share the cell with William. On July 2nd, the mentally ill inmate told another deputy that he's hearing voices saying to kill his roommate. Please note that roommate will be William. William requested that the mental inmate be moved. The deputy pushed William and the inmate back into the cell and locked it. The inmate immediately began to attack William. As William defended himself, he began to yell out for the deputy and was able to restrain the mental ill inmate until deputies came to rescue him. On July 3rd, deputies brought another inmate to share the cell with William. William adamantly requested that they remove him because his mental status was undisclosed. Deputies ignored William's request until William persisted that the man be removed. The deputies became irate and removed him. On July 4th, William asked a deputy, what is his current status, as he was told he was on 24-hour isolation, meaning no interaction outside of his cell whatsoever until his release from solitary confinement on July 31st, 2022. We have proof that William attempted to communicate with our family via email, and the messages were deleted before we could receive them, of course due to their revealing content of violations of William's constitutional rights. We have reason to believe all these egregious actions are the basis of retaliation and plausible instruction from a higher level individual in their official capacity. I'd like you all to keep in mind that Judge Chadia Whitner of the Gwinnett County Superior Court was appointed to her seat as judge by Georgia Governor Brian Kemp. She was not the people's choice through a voted election. Thus, she is not obligated to us, the people. She is obligated to the government in whom placed her, thus her comfortability with abusing her power. In light of all that I shared with you guys today, we seek a form of asylum from the Federal Court of the United States government, that William receive protection of his constitutional rights and due process of law. I ask that you all tag, share, and comment on this video, that there may be some light shed upon this egregious situation before harm comes to my son or our family in retaliation of the fighting back. Post this on social media, tag local and national media stations, radio stations, investigative reporters, human rights advocates, civil rights advocates, celebrities, and influencers. And I thank you all so very much for your time.